Hello everyone, I welcome you all in a course titled as Hindu Personal Law including Marriage and Succession. Friends, I welcome you again in a second week of the course. This week we will focus on the source and school of Hindu law. Source and school of Hindu law is very crucial to understand the Hindu law in proper context. Therefore, the study of school and source of Hindu law is required. Now, before starting anything, I want to recall what we discussed in the last week. We discussed about the meaning, concept and application of Hindu law. What is Hindu law? Hindu law is a law which regulates personal affairs of Hindus, and Hindu considered Hindu law as the part of Dharma, which evolved and developed from Vedas, Smritis, commentary and digest, custom and judicial decision. We understand that Hindu law developed by the scholar which equally applied on king as well as the subject of the king. Therefore, Hindu law declared as a kings of king. We also understand the origin of Hindu law, where we discuss the Bharati perspective and the Western perspective. Bharati perspective, while declaring that Hindu law rooted in the Vedas, therefore its divine origin. Western scholars concluded that Hindu law originated from the custom time immemorial. But Main criticized both the view and concluded that now after the publication of the each and every work associated with Hindu law, we are bound to conclude that Hindu law developed with the text and further it supplemented and modified by the customs. Friends, we also discuss about the application of Hindu law before the constitution and after the constitution and after the codification of modern Hindu law. We also discuss who is Hindu for the purpose of the law. This discussion was very crucial because Hindu law is personal law. Hindu law applied on a person on the basis of the dharma of a person. Therefore, who is Hindu is fundamental questions for the application of Hindu law. Therefore, we discuss that Hindu by religion, person governed under this act, and we also discuss residuary definition of Hindu. We also discuss that if any person converted and reconverted in Hinduism also considered as Hindu. We discussed the different dimension of Hindu in the last week, and now I welcome you all in second week where we focus on the source and school of Hindu law, and very particularly the today's lecture is focused on Shruti and Smriti. Friends, first I want to identify the learning objective of the present lecture. This lecture includes meaning of the source of law. We also discuss about the traditional source of Hindu law. Then we also discuss the subject matter of law dealt by Shruti and Smriti, and we also discuss about the 18 titles of law written under the Vyavhara Adhyaya of the Yagyavalk. Manu also identified these legal heads. Friends, first I want to explain the meaning of source of law, because we are going to study the source of law. Therefore, the first target is how we can explain the idea of source of law. The source of law used in the three sense. The first sense is the authority which issues the rule of conduct that are recognized by the court as binding. In this sense, source of law means maker of law, means authority which issued the law, prescribed the law, means maker of the law. In the second context, the social conditions and problem that inspire of making of law. In this sense, expression source of law means cause of law. Sometime due to the social conditions and due to the social problems, we needs a law, and therefore social conditions become a cause, effect. Therefore, we have a law. Therefore, in this sense, source of law means cause of law. In a third sense, the source of law means the material from which the rule of law are known, means evidence of law. So therefore, we may conclude that the source of law may be placed in a context of three specific expression. The first one is to maker of law, cause of law, and evidence of law. By this, we are able to understand the actual meaning of source of law. Now, I want to focus on the Vigyaneswar contribution. The Vigyaneswar used a terminology for the purpose of explaining the idea of source of law, that is Gyapak Hetu, and where he discussed about three Gyapak Hetu. The first one is Mool, second one is Lakshan, and the third one is Sthan, means root, evidence and place of law. Now the question is, why we should study about the source of law? The answer of this fundamental question is, friends, the different legal system have their own different source of law, and therefore if you want to know law in your legal system, you are bound to understand the sources of your legal system. So this is the reason, therefore we are interested to study about the source of law. The second one is, the every system, only that rule is law which has a place in its source. Means, suppose if your tradition not considered something as a source of law, then what contains in those source have no sense for you or for your legal system. The third one is, the rule which is not laid down therein are in the conflict with what is laid down therein is not a rule of that legal system. Just it is explanatory of the last line, friends. Therefore, the study of the source of law is needed. It also enhances the understanding of the foundation of a legal system. So these are some important points which suggest us we should inquire the source of law, because every legal system have own source. Source provides you foundation and knowledge about the law. So therefore, if we are not aware about the main sources of the law which is recognized in a legal system, then we can't understand a law in proper context, or we are not able to find out the references related with the law. Therefore, the study of the source of law is required. Now friends, I want to focus about the source of law. The Yagyavalkya Smriti chapter 2 verses 7 provides 5 different sources of the Hindu law, which includes Shruti, Smriti, Sadachar, the practice of good man, and self-satisfaction, and the last one is Samyak Sankalpajah, a desire that is spread from the good revolution, friends. Sources identified by the Yagyavalkya Smriti, Shruti, Smriti, Sadachar, Swasasya Sopriya Atmanam, Samyak Sankalpajah. These are the terminology used by Yagyavalkya in order to identify the source of law. In the same context, Manu Smriti also refers the source of law, chapter 2 verse 12, where Manu Smriti provides that Veda Smriti Sadachara Swasasya Chopri Atmanam Etat Chudut Prahu Sakchat Dharmasya Lakshanam. Means Manu considered only 4 sources of the Hindu law: Ved, Smriti, Sadachar, Swasasya cha Pri Atmanam, which we contains first 4 under the above head. The Gautam Dharma Sutra also focused about the source of law, but Gautam identified only 3 first mentioned source as a source of law. Now I want to focus on the prominent source of law, that is the Shruti. The Shruti is very foundational because Shruti is considered the foundation of all the knowledge which exists nowadays. Therefore, I want to start with the meaning of Shruti. The word Shruti is derived from the root Shru, means to hear. To hear means what here? Means it was heard by the sages by the lips of God. The rishis are also considered mantra drishta. So what they heard is exist in the form of Shruti. Shruti means through. Therefore, what is heard? Friends, as Shruti are not written by man, therefore they do not suffer from human defect. Shruti has highest authority of law. It is considered as divine, faultless and self-evident and eternal by Hindu. Therefore, Shruti acquired paramount and fundamental source of Hindu law. How we can explain the Shruti? Manusmriti contains that Shrutistu Vedo Vigyayo Dharma Shastro Tvai Smritihi, means Shruti means Vedas. The same line is also explained by the Yagyavalk under chapter 1 verse 7, where Yagyavalk also concluded that Shruti means the Vedas. Now, in order to explain Shruti, Manusmriti contains a phrase Vedo Akhilam Dharma Moolam Smrit Sile Chadutiyam Acharascha Sadhunam Atmam Tustirevacha. Vedo Akhilam Dharma Moolam. This point is very crucial for the purpose of the identifying the Dharma. Dharma is rooted in the Vedas. You may understand the Dharma with the help of Vedas. Therefore, it is very important source of the law. Now, I want to quote the Medhatithi, where the Medhatithi in the commentary of Manusmriti, he commented that Vedas word referred to the Rigved, Yajurved, Samved and Atharved. Fundamental question is whether the Veds are important and relevant for the purpose of modern law or not, whether it contains legal material or not. Friends, this idea is highly criticized by the scholars, and scholars have a different view, because one group of scholars concluded that Vedas not contains legal material, but another scholars also concluded that no, Vedas contains legal material also. We still not inquire properly, therefore we have the lack of knowledge, and therefore we are thinking that Vedas includes very minimal contents of the law. But I want to refer here P.V. Kane. The P.V. Kane concluded that the Vedic text on the topics such as the marriage, adoption, joint into family, partition, inheritance and Stridhan. We may identify the matters on Vedas about the marriage, inheritance, succession, Stridhan. These provisions are rooted in the Vedas. Therefore, the assumption and presumption that Vedas not includes the legal material is not authentic argument. Now, according to the Ganganath Jha, Shruti operates the following 6 forms of the law or 6 form of the knowledge. The first one is the injunctive or the mandatory text. Vedic text, some portion of Vedic text are injunctive in nature, mandatory in nature, where you have no option. And few texts are prohibitive in nature, which prohibits something. And the third, the few text is also considered as narrative or declamatory text, and declamatory text are also 2 different kinds, commendatory and condemnatory. 2 different kind of the statements recognized in the Vedas. These are the technical terms through which you may understand the spirit of the Vedas as Ganganath Jha explain its Hindu law and its sources. The mantras text, the proper names of the particular sacrifices and the Upanishad text. So now I want to focus on the second important source of the Hindu law, that is Smriti. The term Smriti is derived from the root Smri, and meaning of Smri is to remember. Means Smriti contains those portions of Shruti which the sages forgot in their original form, and the idea whereof they wrote on the basis of their language or on the basis of their memory is known as the the Smriti. Means friends, on the basis of the memory, scholars produce the literature, and literature is known as Smriti's Granth. Friends, in India, Smriti occupies a very important place among the source of law because they contain vast legal material. I bound to conclude that due to Smriti, we explore our legal tradition. And very important and pertinent fact is, before the enactment of the modern codified Hindu law, Smriti were considered the main source of Hindu law. Now I want to focus on the characteristics of the Smriti. Smritis includes because they have a human origin. They are authoritative. They includes a systematic exposition of rules and principles of law, and being human creation, some natural defects of human memory and understanding is also there. So these are the basic characteristics of Smriti: human origin, authoritative, and systematic exposition of law is there, and human creation, therefore defects are also there. Friends, now I want to focus on the origin of the Smriti. Smriti have origin in ascetic, because Smritis are known as ascetic composition. So why ascetic composition? Because Smritis writers were ascetics. Sages written the Smritis. King not produced, not let down, not provides delegated power to them to write such kind of rules. Scholars, on the basis of their knowledge and satisfaction, they produce different kind of Smritis for the welfare of common people residing on this Bharat Bhumi. Scholars hold no political powers, but had the utmost respect and reverence in the society, and because of their wisdom and sadachar. Why Smritis recognized by the people as well as by the administrator? Because of the scholarship of the Smriti writer and because of the sadachar of the Smriti writers. So because of these qualities, they were highly respected in the country. Therefore, due to the scholarship, it was applied in the administration of justice in Bharat. Therefore, friends, we are again conclude the issue that the king was not the maker of dharma, which includes also the law. Therefore, it is true that the origin of Hindu law lies in ascetics and not in the royal command like the Austinian command. Now I want to focus on the rule of the Smriti. Smriti contains three different kind of the rule. The first one is achar. It is very close to morality. The second one is the Vyavhar, and Vyavhar is a dynamic and very exhaustive and highly relevant for the purpose of law. It signifies those rules which the king of the state have to apply for the settlement of the dispute in the administration of the justice. The Narad Smriti highlighted the emergence of Vyavhar in the Indian tradition, where Narad concluded that when people forgot their dharma and the dharma of the people was destroyed because of the non-observance, then the role of Vyavhar emerged in practice. We are aware about a very famous sutra of Mahabharata, Na Dando. We concluded that at the origin of the history, people followed the dharma, na dando na cha dandikah. The same is Smriti. The same kind of the idea also further argued and noted by the Narad, where Narad noted that naste dharme manusyanam vyavharah pravartate. Drishta cha vyavhara rajam raja dandadharha smriti. Means, due to the decline of dharma, Vyavhar came into existence, which prescribes binding natures, prescribes rules, and compel people to follow the path of law. Therefore, on that basis, we can conclude that Hindu law is not a morality only. This is the legal perspective of the Hindu tradition, and this jurisprudential system also have a very proper root about the law. The third rule of Smriti is known as the Prayaschit. The Prayaschit may be explained by two different explanations. The first one is an inner desire to reform oneself, and the second, a readiness to undergo the punishment for committing an offense. Means an inner desire to reform oneself, readiness to undergo the punishment. Means you are ready because you are willing for Prayaschit. Prayaschit is internal, not external. So therefore, entire Smriti's text categorized in three fundamental categories: Achar, Vyavhar and Prayaschit. Vyavhar is highly related with the law, and which I discussed with you that due to the decline of Dharma, law emerged and Smritikar laid down the specific rules for the purpose of the controlling the people residing in the territory of Bharat Bhumi. Now I want to focus on the Dharma Sutras, because friends, Smritis may categorize in two different categories: Dharma Sutra and Dharma Shastra. So now I want to focus on Dharma Sutra. Dharma Sutra generally written in the prose form, and there are 5 important Dharma Sutra recognized in Indian traditions: Gautam Dharma Sutra, Bodhayan Dharma Sutra, Apastambha Dharma Sutra, Vasishtha Dharma Sutra and Vishnu Dharma Sutra. These 5 Dharma Sutra are very prominent in our traditions, which prescribes certain rules which are very relevant for the purpose of law. So first I want to put my focus on the Gautam Dharma Sutra. Gautam belongs to the Samvedi school. Gautam Dharma Sutra deals extensively with the legal and religious matter. It also deals with the subject matter of law, inheritance, partition and Istridhan. The Gautam focused on the tradition, practices and uses of the people. These are some fundamental observations about the Gautam Dharma Sutra. Now second is the Bodhayan Dharma Sutra. Bodhayan belongs to the Krishna Yajurved branch. It deals with the subject matter of marriage, sonship, adoption, inheritance and various customs of which is prevailing that time. The next one is the Apastambha Dharma Sutra. Apastambha belongs to the Krishna Yajurved. Apastambha deal with the specific aspects of the law of marriage, inheritance, and Apastambha also focused on the criminal law. Now I want to focus on the Vasishtha Dharma Sutra. The Vasishtha Dharma Sutra is also very prominent Dharma Sutra. It recognized only 6 forms of marriage and excluded the Paisach and Prajapatya kind of marriage under the definition and kinds of the marriage. This Dharma Sutra permit the marriage of the virgin widow, therefore it also considered as a progressive Dharma Sutra. The another important Dharma Sutra is Vishnu Dharma Sutra. Vishnu deals with the subject matter of criminal law, civil law, marriage, sonship, adoption and inheritance. Vishnu Dharma Sutra is closely connected with the Manu Smriti and Yagyavalkya Smriti. So these are the first category of Smriti which contains under the head of the Dharma Sutra, because Smritis are categorized in the form of Dharma Sutra and Dharma Shastra. Generally we are also using Dharma Shastra terminology for expressing all the tradition which is associated with the Smritis. So this is the first part written in the prose style, Dharma Sutra. Now I want to focus on the Dharma Shastra. What is the Dharma Shastra is the first fundamental question. Dharma Shastra means science of law or text of the law. Dharma Shastra is a science to analyze, interpret, determine, define and final the characteristics of dharma and law. Means with the help of Dharma Shastra we are able to analyze the law, interpret the law, determine the law and finalize the characteristics of dharma and law. Therefore Dharma Shastra is very crucial, friends. As Manu is stated in the Manu Smriti, Dharma Shastra tu vai Smritihi, means Dharma Shastra means Smritis. Therefore I want to focus on the Smritis. The first fundamental question is the number of Smritis are name of Dharma Shastra. Although I am not clear about the number of Smritis because different scholars quoted different numbers. But I want to rely on the Yagyavalkya Smriti, where Yagyavalkya noted list of 20 Smritis, and he suggested that these are the 20 Smritis. I want to focus on the few name: Manu Smriti, Atre Smriti, Vishnu Smriti, Harita Smriti, Yagyavalkya Smriti, Angiraz Smriti, Apastamba Smriti, Katyayan Smriti, Brihaspati, Parasar, Vyas, Sankh, Likta, Daksh, Gautam, and Vasishtha Smritis. Means the number of Smriti, we are not to say something rigidly, but I want to rely on Yagyavalkya, where Yagyavalkya let down the list of 20 Smritis, which are very relevant for the purpose of the studies. Now I want to focus on the prominent Smriti, that is the Manu Smriti. According to Brihaspati, Manu hold the first place because he has expressed in his code the sense of Vedas. So Brihaspati put extra emphasis on the Manu Smriti because according to Brihaspati, Manu Smriti favors the sense of Vedas. Therefore, Manu's preeminent position is accepted not only by Hindus lawgivers but also by the Buddhist writer of the Java, Siam and Burma. The Manu Smriti not only recognized in the Indian territory, it also recognized beyond the India, where the scholars derive their principles of law from these holy books. Manu Smriti contains 12 chapters and also contains 2694 slokas. Manu Smriti also deals with Vyavhar, and for this purpose chapter 8 is very crucial for the purpose containing the different heads of Vyavhar, where Manu recognized the 18 Vyavhar Pad. This 18 Vyavhar Pad is very important. Vyavhar Pad means matter of law or title of law or matter of dispute. I want to try to explain some meaning of the terminology. For example, in Hindi or in Sanskrit, for example, Dand Parus, Vakya Parus, Sambhu Samusthán. The different kind of terminology are used in the context of the Vyavhar. For example, non-payment of the debt, deposit and pledge, sale without ownership, concern among the partners, resumption of gift, non-payment of wage, non-performance of agreement, assault, defamation, theft, robbery, duties of man and wife, partition and gambling and beating. Dut Samadhyaya. 18 heads of the legal title given by the Manu. This point is also dealt by the Yagyavalkya in the Vyavhar Adhyaya, and this 18 title is also further classified by the Narad as well as by the Kautilya. Means friends, you are able to identify 18 title of law from Manu, Yagyavalkya, Narad and Kautilya Arthashastra. They widely classified the Vyavhar, and Vyavhar is purely a legal discourse which exists in a Smriti. I want to focus on the Harita Smriti. This work is known as Harita Smriti and not available in its original form. Other Smritis, commentaries and digests refer the provisions of Harita Smriti while they are interpreting and explaining their Smritis, friends. The another prominent Smritis are Yagyavalkya Smriti. This is more logical and synthesized than Manu. Manu Smriti translated first in India, therefore Privy Council used to use Manu Smriti, but Yagyavalkya Smriti detailed contained the law, and the Vyavhar part, chapter 2 of the Yagyavalkya Smriti is so exclusive about the law, about the each and every portion of the law, and therefore it is a very preferred reading when you actually interested in to know the root of Indian law. Manu, Yagyavalkya especially focus on the law of marriage, partnership and the association of person, joint business and some objects matters of these Smritis. The another prominent Smritis are Narad Smriti. Narad divided the subject into two parts. First deal with the judicature and second enumerates and discuss the remarkable clarity of the 18 title of the law. The 18 title further explained by the Narad with classical definition and clarifications, friends. The Narad focus on the law relating to inheritance, ownership, property, gift and partnership, shares of the widows and share of unmarried sister are some important subject matters covered under the Narada Smriti. Narada Smriti is very scientific. If you really interested to know the evidence law in Indian roots, for the purpose of evidence law, Narada Smriti is extremely good. For the purpose of property law, division of property, possession, bhukti, everything, swamitva, bhukti, sakshi, praman is broadly mentioned in the Narada Smriti, and therefore this is very crucial to understand the entire Indian legal traditions. Friends, now the question in the case of conflicting Smriti, friends. Different Smritis deal some same subject matter. These Smritis have been written in the different part of the country in different span of the time. Therefore, the differences and even contradictory opinions are quite natural. Therefore, in the case of Rao Bhagwan Singh versus Rani Kisori, the Privy Council observed that interpretation of Smriti text is not simple, as it is not the literal interpretation alone that has to be considered, but the cogent meaning of the words also to be considered into the consideration. These Smritis do not contain purely positive law, as they also contain religious and moral aspects of life. Therefore, Privy Council emphasized the necessity for being cautious in interpretation of Smritis. Privy Council want to contain. Privy Council suggested that we should be very careful when you are going to interpret the provisions of Smritis or verses of Smritis, because it contains vast material. Therefore, clarification is required for the purpose of understanding the proper law. Now I want to focus on the rule to resolve the conflicting provisions of the Smriti. The first fundamental rule is no conflict should be admitted where it is possible to reconcile two texts. If you are willing to possible to reconcile them, conflict should be avoided. The Narada Smriti laid down a principle in chapter 1 verse 40, where he provides that where there is a conflict between two Smritis text, preference should be given to anyone which is in accordance with the equity, justice and reason. Therefore, friends, the Narad tell us that dharma sastra virodhe tu yukta yukto vidhi smriti. This is the point. The next is, friends, the scholar also concluded that Manu Smriti is supreme. Therefore, if the provisions of other Smriti in contravention of Manu, then such provision is not authentic. The next is, in the case of conflict between the rules, if one relates to the visible objects, drishtarth, and the other to an invisible object, then the later is more authentic. Now I want to focus on the think on certain points, friends. And before thinking that, I want to focus on conclusion. The two prominent sources of Hindu law contains Shruti and Smriti. Shruti means what was heard by sages, divine source. Therefore, Vedas is fundamental. Vedas also contains legal provisions, legal principles and philosophy. But Smriti is very fundamental for the purpose of application of law. But we should think about that where there is a conflict between different Smriti, we will focus on the logical part of the Smriti. So long as you are able to avoid the conflict, you may avoid the conflicts. This is the discussion and discourse. Think about certain points, friends. How do the Shruti and Smriti differ in terms of their origin? Second point, was the scope of law confined to only 18 title of law? The third is, do Dharma Shastra contains provisions related to morality, ethics and spirituality only? These are the 3 points which should be considered when you are go through with this lecture. So friends, this is the point through which we understand the idea of school of law, makers of law, cause of law, evidence of law. Then we understand the observation of Vigyaneshwar, and we also understand the idea of Shruti and Smriti. And in a case of conflict between Shruti and Smriti, Shruti will prevail. In the conflict between the Smritis, logical provision of the Smriti will prevail over the illogical provisions. And in a case of conflict, the custom and good practices which is available in the public will prevail over the Smritis. These are the contents. Thank you for your patience.